hello, how are you? Let us come into the new topic, interpretation of statutes. With me, Vidya, law made Saral. Okay, what is interpretation of statutes? Interpretation is nothing but how, why, how, is it possible, the translation, explanation, what kind of meaning we are getting through that is called interpretation. And statute is nothing but a kind of law made. Okay, let us quickly go into the introduction. When we say the interpretation of laws, that law can be of any type. Maybe it is a natural law, or it may be a law made by the king or a queen, or it may be a law whose origins are lost in time. When we interpret a law, the basis can be a moral basis, or it can be a religious basis, or it can be a historical basis. In this, what we are trying to say is the law can be of any kind. It can be made in the country, in a state, or by the legislature to make and use it. Like we have many kinds of interpretations, like what kind of interpretation is taken in a family law. There is difference in interpretations of family law in Hindus as well as Muslims. So the kind we are taking the law in our perspective view is called interpretation. So when we are going to, for example, when we are invited to a occasion, like for example, when we are given a greeting card or when we are given a wedding card for an invitation, so the invitation says like you are supposed to attend the so and so in ceremony on first floor or second floor, whether it is on the first floor or it is on the second floor. There is no such clarity. There is ambiguity. There is no clear-cut idea of whether it is the ceremony is conducted on a first floor or second floor. Whether we are allowed to go into the ceremony on first floor or second floor. So there is kind of ambiguity. Okay. So statute law is the law which is basically passed by a legislature and is available in a codified manner where everything is written down in the official language of the state in black and white. So they are saying legislature passes the statute laws, yes or no? So and it is written in official language, the official language which with whose perspective, the lawmakers' perspective they are making. So they are making some long time ago and it can be codified later upon the time. But for now being, what is statute and how is it connected with that people and how is it implemented, and if there is an ambiguity, if there is any difference in ideas, then the interpretation comes into the picture. As such, a basic question arises, which is that when such statute law, especially the modern acts and rules, are drafted by legal experts, and it can be expected that the language used will leave little room for further interpretation or construction, then where is the necessity for interpretation at all? This is the question, like when there is a difference in reading, when there is a difference in understanding, when there is a difference in explanation, like for example the English has so much of difference in US based English, UK based English, Indian English, and so on and so on. For example, in the past READ is pronounced as read. In the present times it is written English language, it is written that READ, and it can be pronounced in the present tense as read, and in the past tense as read with the same spelling. So there is a kind of interpretation of what is read in the past and what is read in the present. So this kind of ambiguity may arise in the language. Especially in English, we have different kinds of variations and slangs. So the answer to the question is that it is not necessary that the words used in a statute are always clear, explicit and unambiguous, and is thus in such cases it is very essential for courts to determine a clear and explicit meaning of the words or phrases used by the legislature and at the same time remove all the doubts about the statute. Though the words statute and law are generally used as synonyms of each other, there is a clear-cut distinction between them. The term law is a wider term and includes within it a statute law. Statute law is a narrower term and it is the law made by the legislature. So, nothing but statute is nothing but a law, but law is a complete picture and statute is one of its pixel. So, we can say law is a wider sense and statute is one of its elements. So, statute is a law, but the law entire is having many such statutes. So, Black has defined statute in some other way. A statute is a formal written enactment of a legislative authority that governs the legal entities of a city, state or a country by way of consent. The word statute is derived from the French word statute and from the Latin statutum, which means to set up, decree, establish, the status to be established. So, the modern meaning of the term statute is that it is a law passed by the legislative body and set forth in a formal document in some other context. The document itself is called as a statute. International law, an instrument annexed or subsidiary to an international agreement as a treaty, is also called as statute. What is the meaning of interpretation? So, interpretation, I already said, to explain, translate, understand, think and elaborate. So, these are the kinds of meanings in a dictionary given. So, what is interpretation is the process of explaining, expounding, translating any text or anything in written form. Another definition can be that the interpretation of statute is the correct understanding of the law. This process is commonly adopted by the courts for determining the exact intention of the legislature which has created that statute. Sir John Salmon also gave one definition. We have studied about the Blackstone's definition, and now this is given by the John Salmon. By interpretation or construction of a statute is meant the process by which the court of law seeks to ascertain the meaning of the legislature through the medium of authoritative form in which it is expressed. So it is the legislature which has to give the correct meaning and ascertain a correct meaning of what the statute really meant and how it is expressed. So, the function of the judiciary is not only to interpret the law for academic purposes, but such interpretation is invariably arises at the time of implementing the law. Therefore, interpretation of a statute is of utmost importance because the objective of the court is not only merely to read the law, but it is also to apply the meaningful manner to suit. From case to case, it differs, right? It is also used in ascertaining the actual connotation of any act or document with the actual intention of the legislature. There can be a mischief in the statute which is required to be cured, and this can be done by applying various norms and theories of interpretation which might go against the literal meaning at times. So, all these we have read what interpretation is, what statute is. So, the interpretation of statute therefore is the art of finding the true sense of the enactment by giving the words of enactment their nature and ordinary meaning. So, the court of law is not expected to interpret arbitrarily, and therefore there have been certain principles which have evolved out of the continuous exercise by the courts. These principles are sometimes called rules of interpretation. So, there are certain rules to interpret about that statute. So, thus the true object of the interpretation is to interpret the statute to find out the real intention which is made by the legislature in giving the enactment. Okay, so when does the necessity comes for the interpretation? So when there is the language or the statutory provision is having some ambiguity, when it is not clear, when there are two other ways or views which are possible, when there is a provision which gives different meaning defeating the object of the statute. If the language is clear and unambiguous, there is no need of interpretation. Yes. So, when in the two cases, in R.S. Nayak versus Antulle and in Grasim Industries Limited versus Collector of Customs Bombay, so the in legislature, the interpretation of statutes has been given by the legislature, and they have been given the true meaning and the true idea behind the statutes. So, where the words are clear and there is no ambiguity and the intention of the legislation is clearly conveyed, so there is no need of interpretation of the statutory provisions. In this we have read about in these 4 slides we have read about what is interpretation of statutes. Interpretation is nothing but to understand, explain, translate in a wider sense what is the statute. What is statute again? Statute is a little law which is made by the legislature and it is a provision which is made by the legislature for that concerned state regarding that concerned authority regarding certain principles. It can be a declarative and it can be a application. So we have all these kinds of interpretations. So what are the types of statutes? We have 7 types of statutes. They are codifying, validating, repealing, declaratory, remedial, consolidating and penal statutes. So with this we have completed the first episode of this interpretation of statutes, and in the next coming video we'll discuss about these kinds of types of statutes and their explanations. Thank you for joining me on this context. Thank you.